What if a centuries-old piece of legislation suddenly became the linchpin in one of the most contentious immigration decisions in modern American history? How would it transform the nation overnight, and who stands to gain or lose the most? Stick around to the very end to discover the one surprising twist that could change everything about this unfolding story. Welcome back to our channel, where we break down the biggest White House news of the week. Today, we're discussing something few people saw coming. A 1790s-era law has re-emerged as a powerful tool for immigration enforcement. President Donald Trump has recently signaled he might lean on a centuries-old measure, commonly referred to as the Alien Enemies Provision, to detain and even deport specific groups labeled as alien enemies. This move has sent shockwaves through Washington, D.C. and across the country. Immigration debates have always been polarizing, but the potential use of a law that dates all the way back to the John Adams administration has raised fresh questions and a few eyebrows. Opponents argue that this is an extreme step that tramples on modern democratic values. Supporters see it as a bold maneuver finally matching the scale of the illegal immigration crisis. So, what's really happening? What does this law entail? And how could its resurrection affect both the American people and those living in the country without proper documentation? Let's unpack the details. First, let's clarify the origins of this legislation. In 1798, amidst tensions between the United States and revolutionary France, Congress passed a series of measures commonly known as the Alien and Sedition Acts. Part of that package included the Alien Enemies Acts, which granted the president the authority to detain or deport non-citizens from enemy nations during times of declared war or conflict. While most parts of the broader Alien and Sedition Acts were either allowed to expire or were deemed unconstitutional, the Alien Enemies Act survived and remains part of US law. Historically, it has been used sparingly. In fact, one of its notable uses was during both World Wars, when individuals from hostile countries were sometimes detained. The idea of using it in peacetime, or in what the administration might call an undeclared border crisis, is highly unusual. Supporters of this move argue that illegal immigration has reached critical levels. They point to overcrowded detention facilities, rampant drug trafficking, and the ongoing challenge of securing the southern border. By invoking a law as old as the Republic itself, they argue that the administration is reasserting its rightful authority to protect citizens from foreign threats, including individuals who might arrive unlawfully, commit crimes, or otherwise pose dangers to public safety. From this viewpoint, the Alien Enemies Act is not so much an outdated relic as it is an underused tool. The Trump administration maintains that they are simply enforcing laws that have always been on the books. By positioning certain categories of non-citizens as enemy aliens, the administration could potentially streamline legal processes around detention and deportation, especially if it can make the case that these individuals threaten national security or public order. Unsurprisingly, this hasn't gone without vocal opposition. Civil liberties groups, immigration advocates, and some members of Congress argue that branding undocumented individuals as alien enemies conflates immigration violations with acts of war. They caution that setting such a precedent could erode civil liberties and legal protections that have been built over decades, if not centuries. Critics claim 1. Constitutional overreach. They see the use of a 1790s law to detain modern-day migrants as a potential abuse of executive power. They suggest that the original context, wartime with a clearly defined enemy, doesn't neatly translate to the present situation. 2. Fear and uncertainty. Many worry that broad use of this law will sow fear in immigrant communities, discouraging individuals from cooperating with law enforcement or seeking legal pathways to citizenship. 3. Impact on innocent people. Opponents caution that without strict guidelines, people who pose no threat could get swept up in deportation efforts, damaging families and local economies alike. However, in the face of these concerns, the administration insists that the law will be applied judiciously, focusing on those who pose the greatest risk. From an economic standpoint, supporters believe that stricter enforcement could open up more jobs to American citizens, ease strain on social services, and reduce crime rates in certain areas. By tightening the removal process, they argue, The government can tackle entrenched issues such as gangs and drug cartels operating across the border. National security hawks view this as a logical extension of defending American sovereignty. If every nation has the right to decide who enters and who remains within its borders, then employing every legal measure on the books is simply a matter of defending national interest. There's also a perception among many that public safety could improve if dangerous criminals here illegally are removed faster. In this line of thinking, everyday Americans, particularly in communities along the southern border, stand to feel safer if they no longer have to worry about revolving door policies that allow repeat offenders to slip through cracks in the system. For immigrants, especially those here without documentation, the move signals a seismic shift. Already, many describe feeling an elevated level of uncertainty and anxiety. If the government broadens the definition of who qualifies as an alien enemy, the ramifications could be huge. Detention facilities could see a sharp rise in population. Migrants awaiting hearings or deportation could be held for longer periods. Given the enemy label that implies a threat to security, deportations might be expedited for those deemed part of a hostile group, bypassing some of the usual legal procedures that protect asylum seekers or those with mitigating circumstances. Immigrant communities may become reluctant to report crimes or cooperate with local authorities, fearing they might be caught in a wider net. Some critics worry this may feed into negative stereotypes, while supporters argue it will deter future illegal crossings and bring greater accountability to those who violate immigration laws. The biggest question remains whether courts will uphold a peacetime invocation of a law specifically designed for wartime conditions. The legislation explicitly states it's applicable when a formal declaration of war exists, or when the nation is under threat. Given that no formal war is currently declared, the administration would need to firmly establish that these aliens fall under the category of enemies. Legal experts warn of a coming battle in the courts, with lawsuits likely to challenge whether the modern context justifies using this historical statute. Regardless of the outcome, the process could take months, or even years, to resolve fully, and the Supreme Court may ultimately have the final say. Politically, this move highlights just how polarized America's immigration debate has become. For many voters concerned about border security, it's a long overdue tough stance. They see the reintroduction of this 1798 law as a sign that the administration is serious about addressing illegal immigration and willing to use all tools at its disposal. On the other hand, moderate Republicans and Democrats often caution that such an approach is too extreme, raising moral and constitutional questions that could alienate independent voters. The bigger risk is whether invoking something as drastic as the Alien Enemies Act will overshadow more moderate immigration reforms that might have bipartisan support. Remember our opening question: what if a centuries-old law changes the way our country handles immigration overnight? And who stands to gain or lose the most? Here's the twist. Legal scholars are hinting that the administration might also look into other long-forgotten statutes if this move is successful. That could mean an even broader reshaping of federal authority to regulate immigration, national security, and domestic policy. If that happens, we could be looking at a new era in American law enforcement, one guided by legislation most of us thought was permanently relegated to the pages of history. Whether that's a good thing or a cautionary tale will likely be debated for a long time to come. The potential use of the Alien Enemies Act signals a dramatic escalation in the ongoing battle over illegal immigration. Supporters see it as a bold, necessary stand to safeguard American jobs, security, and sovereignty. Critics warn that it risks constitutional overreach and sets a precarious precedent. One thing is certain: as this story develops, the tension between national security and individual rights will shape the discourse in Washington and across the nation. Will the courts greenlight this historic interpretation of a 1790s law, or will legal hurdles stop it in its tracks? Only time will tell. Thank you for joining us for this breakdown of the latest White House developments. Don't forget to like, subscribe, and share your thoughts in the comments below. We'll keep you updated on every twist and turn in this unfolding saga. So stay tuned for more as we bring you the truth, one headline at a time.